Hello and welcome to today's episode of On the Mark Financial Literacy with Mark Zinman. Good morning, Alicia.
Good morning.
Good morning. Good morning, Mark.
Good morning, Monica.
How are you today?
I'm doing good. I'm doing very well. Thank you. Enjoying my summer. Actually, it's a beautiful day out today, so.
It is.
Yeah. I did want to share with the audience that, the production value in here, and I'll get Alicia's vote. Who's the last person ready before we do the podcast? She's being very quiet.
Monica.
Yeah. Okay, just want to make sure.
I'm a busy individual.
Yeah. Maybe we should call it When Monica's Here.
Today,
Yes.
we're going to be talking about revocable and irrevocable trusts, and we're also going to be talking about power of attorney. Is that right?
That's right. Very exciting topics. Very exciting.
All right, let's jump right in.
So I think the first thing we need to talk about is a lot of these things are tied into estate planning, especially when we talk about revocable and irrevocable trusts. And I may get viewer mail from this, but I think a lot of times attorneys oversell trusts. It's part of their fee structure. There's nothing wrong with them. It's just that they're not always necessary. And I think we talked in our estate thing about having to file a will, having to probate it, and them selling the trust as a way to avoid that. It's not bad to have to probate, and most of the officials. I know, for example, where we live, the Register of Wills is extremely kind and very attentive to people who do it on their own, and maybe a little less attentive and a little less helpful to the attorneys who walk into the office who should already know how to do it. So it's very important to know. But as part of this, there's two types of trusts: revocable and irrevocable. A revocable trust is one in which you can revoke it at any time. And for the most part, a revocable trust becomes irrevocable when you die. So when people put things in trust, irrevocable trust, that revocable trust stays on until such time as something causes it to become irrevocable. And that usually is death. Okay? And why do people pick one versus the other? A revocable trust is one in which you put your assets in a trust and you control them. And you can do whatever you want with them. And the reason they're irrevocable is you could say, I want to disband this trust, I want to spend money doing this or taking a vacation. An irrevocable trust, you give up all control on your money. So there is a trustee, and that trustee is the one that you have to go through in order to spend the money. Now, a trust could be set up in a manner in which there are certain things that are given that the trustee, like living expenses or medical expenses or school, and we see revocable trusts in estate planning, and we see trusts generally related to death. A lot of times it's with children, right? So you have minor children, and you definitely do not want the person to be the trustee who's also the guardian. It's like having the fox guard the hen house, right? So you want to have a different trustee than a beneficiary, or than the person who's taking care of that. So it's very important to understand these terms because they're thrown out at you. So people come to me as an accountant and they automatically trust what I say. But I always believe trust but verify. So you go to an attorney and you're saying, I need to figure out what I'm doing for my estate plan. And the attorney says, well, I think you need this trust or that trust or more than one trust. And that may be true, but you need to understand, if I have a trust, what's the benefit? If I don't have a trust, what's the penalty? And then make your decision based upon a completely informed thing rather than just throwing out things, because complexity in estate planning and complexity in forming trusts have the cascading effect of affecting the people who you then appoint to work with you. And if they don't know, or you make it overly complicated, then the cost of maintenance could be ridiculously high. The benefit that you were trying to obtain isn't the value obtained because of the costs involved. So there's a lot of things revolved around trust that you need to understand. And it's the same thing with everything we'll talk about. Ask questions. Make sure you understand all the pros and cons. And to the extent that you're not sure, ask again. That's what you're paying for. That's what you're paying an accountant. That's what you're paying an attorney for.
Mm-hmm. So your advice would be to consult with both an accountant as well as an attorney before you make your decisions, is that correct?
I think that from a financial point of view, there's three people that should be involved: an attorney, an accountant, and a financial advisor.
Okay.
And depending on what this thing is, you should always have two, but sometimes you maybe need three. And the only reason is just maybe to bounce the idea. So if an attorney recommends something and you're not exactly sure, and you call me as an accountant or whoever your professional advisor is, then we either can explain it to you in different words that you may understand, or we can call the attorney and say, like, I'm not exactly sure why you did this, and I'm just trying to make sure that Jane Doe understands before they sign stuff. But a lot of times, from my perspective, I don't find out about this till after the fact. And then there's nothing I can really do, and you don't want to ever say, well, you could have, okay? And it doesn't mean that what you picked was wrong, it just means that you didn't consider all your choices. You just were led down a certain path without being told everything. And I'm not knocking lawyers. They do a great job. I'm just saying, like, a lot of times they assume, the same way I assume, that the client understands, and they don't, and then when they don't ask questions, we just move forward.
Yeah, and that's a good introduction, because it is a very complicated, there are a lot of nuances to be considered at the individual level, so it's a good introduction and good guidance to make sure that each individual treats their situation with the respect that it deserves, because it has a long-lasting impact.
Right, I think that everything, you should game plan. And I say this to people all the time, and I've probably said it before. You imagine a meteorite hits you 5 minutes from now, or a bus falls on you, or something catastrophic that's kind of silly, but, talks about your demise. And other things, and just sort of plan out, like, what happens if, and try and go over each scenario that's possible to make sure that your wishes are being fulfilled as you go down the line.
Mark, on an earlier episode, you had introduced the topic of adding someone else's name, such as an adult child, to your checking account. You wanted to provide some more information on that on a future episode. I think that's today's episode. Do you want to speak to that?
Yes, so we were just talking about trust, revocable and irrevocable, and a lot of these are as part of the estate plan or the later in life taking care of mom and dad type plan. There are trusts that you might put in. Let's say you had a special needs child or something, that would be earlier in life, but I'm sort of sticking to this right now. So a lot of children help out parents to manage their finances as they get older. And the most common thing I see, which is a mistake, is that they add themselves to the bank account. So instead of it being Monica, it's Monica and Alicia, okay? As opposed to having Alicia, in this example, be a signer on an account that's still in Monica's name. And you say, okay, well, what's the big difference there? Well, the big difference there is that when you add somebody's name to an account, if it's one person or it's two people, you basically have gifted them either 50% or 2/3 in the case of three of the value of that account at the time that you add their name. And in most cases, it's an unperfected gift, meaning that nobody realizes they did it, so they're not filing the required gift return for somebody whose value of the gift is more than $18,000. And so when you do that, you're leaving a gap in your estate where you may be putting a burden on the trustee or the executor that you don't even realize you're doing. Because remember, I've said this in an earlier episode, the executor or executrix has a higher level of responsibility than actually the person does. Okay? So we don't want to add children's names to the titling. And where I see this come up is when the mom dies, all of a sudden the child realizes, well, mom and dad had $50,000 in the account when they died. My name's on there. We only have to report 25. Okay? And they often, get away with it because nobody's checking it, but that's not the right way to do it. And the other issue is liability. So when you gift something to somebody, you're getting rid of it, and they're giving it to them. So I gift you a gift, Monica, and it's your money, and then no matter what happens, you get to spend it the way you want to. Well, especially with minor children who may be in their productive years, who may be susceptible to lawsuits or something else that occurs in an active part of your life, and it's rare, but it's there, you basically are now exposing that asset to their creditors. because then they actually own half your account or a third of your account, and that wasn't the intention. Okay?
So that makes me think, so if we could just sidebar for just a moment, get slightly off topic.
I do that all the time, so we can do it.
It reminds me of, on a previous episode, we talked about if you are an adult and you have a child who perhaps is a minor, has not yet reached age of majority, and you put their name on a credit, you give them a credit card that has their name on it, are you making them responsible for your debt? And we talked about that already, but something we didn't talk about is sometimes if you are, certainly in a position to do so, a parent will buy a child their vehicle, their first vehicle, if you're lucky enough to be in a position to do so, and that vehicle may be in the parent's name. So if there should be an accident, if you have a vehicle, I told you it was a sidebar, if you have
Monica from New Jersey.
Monica from New Jersey is asking, if I have a child, and I have bought my child a vehicle, and that child, knock on wood, is in an accident, am I potentially exposing my assets because the vehicle is in my name?
You are, but that's maybe the exception to what I just said. Because for the most part, especially if it's a person under the age of 18 and maybe 21, it's going to be hard to put the car in their own name because they're not able to have it, depending on the age of majority in your state. Further, it's quite often a dependent child, even through college, will remain on the parent's auto insurance. Quite often, and I'm sure that some of our listeners, that when you add your 16 or 17-year-old, see their insurance go up by multiple percentages, because that's a risk that they have. So again, when we talk about risk, we also talk about insurable risk, and the risk of that child getting in an accident, and hopefully not bodily harm, but doing property damage or something else, is covered by your insurance, and you should have ample insurance, including an umbrella policy. So I just want to review what an umbrella policy is. So you could have homeowners insurance on your home, you could have auto insurance on your car. An umbrella policy, and then each of those policies has a limit of liability, $300,000, $500,000, whatever the policy is. An umbrella policy sits on top of those personal policies. So if you had an event that exceeded the liability of either one of those policies, this policy would then kick in and offer it's $1 million, $3 million, whatever. And so people who have more assets would want to have an umbrella policy. And it's not all that expensive. I mean, I think I saw a bill for one like that's $3 million, was $800 a year. It depends on what you think, but $3 million for $800 doesn't sound like a lot if you're going to get that $3 million. But that's, and my experience over the years have been most attorneys who have a viable liability case are very much interested in getting the liability limits of the policy and not necessarily going against the person's personal assets. But that's always a risk. It's just the same thing, we talk about forming entities for liability protection, having insurance for liability protection, out of best title things. In this case, I'm fine with the kid. It's just normal. It's abnormal to have the child have their own policy. Now, it's possible that I don't see this happen often, but if the child reaches maturity, 18, 21, and you want to title the car in their name, that's a gift. And then they can have their own insurance, and the payment of the premiums, if you paid it, would be a gift. And all those gifts would count against that $18,000 exemption.
So we're as we circle back here to our original topic, we're talking about making informed, educated decisions.
And we're talking about topics that are difficult for people to talk about. Their own demise, their state, how they want things. Nobody wants to think about it. It's tough, and I get it, but we're all adults who are listening, unless you're under the age of 18 and listening, in which case we'll have a cartoon break in a minute. But you need to, adulting means you're going to need to deal with this.
Right. And these are three different topics that require that due diligence and that informed decision making. Okay. We also wanted to talk about power of attorney. There are different types of power of attorney, general, springing, financial, medical. You wanted to talk about power of attorney today. Would you like to jump in on that topic next?
So it's very important for whomever you are delegating responsibility to at some point to know that they're the person delegated the responsibility and let them know your wishes. So we see powers of attorneys often, and there are specific use powers of attorney. I'll give you an example. I'm on vacation, I'm selling a piece of property, I appoint Monica as my representative to sign the paperwork. That's a single-use power of attorney.
You're on vacation, you're bringing another parent's minor child with you.
Right. So there's all kinds of, so you could delegate somebody else, but obviously in order to be legally bound to the document, you have to have had the authority to sign the document, and that's what the power of attorney does. So we talked just a minute ago about putting names on things. Well, you could have a power of attorney for financial things, in which case part of it is getting your name on there. If you have an incompetent, I'm sorry, you can't have an incompetent parent because obviously that wouldn't work, but if you have somebody who maybe can't get to the bank or whatever, then maybe having a power of attorney that you can go into the bank and get your name added to the bank account is something. I truly believe that anyone who does a power of attorney needs to have an attorney do it and not pull a form off the line. It's just really important to make sure that if you're going to have some type of power of attorney, just like a trust, that you understand what you're allowing and what you're not allowing.
Okay, so let's specifically talk about a medical or healthcare power of attorney and DNRs.
Okay, well, a lot of times the medical power of attorney goes with the estate plan. This is a tough topic for everyone. I know it's tough for me. My wife said, well, do you want to be on life support? I'm like, I don't know, what's wrong with me? I mean, if I'm never going to get off life support, then I don't want to be on life support, but, I don't want to be taken off life support if I could have recovered in 3 days, right? So it's kind of, I think a lot of people feel that way, but you have to really think about that. And if you're going to allow somebody else, and it's usually a spouse, to get a power of attorney on your medical, it could be a child, then you need to know you need to really be clear on what your wishes are, because that medical power of attorney allows them to make medical decisions for you. It's different than a DNR. Mm-hmm. It could be, a DNR could be part of that, theoretically, but
two separate entities.
But it's two separate documents, right?
Yeah.
But you could tell them, I don't want to be on life support, okay? And in which case, then either you sign a DNR at some point, or if there's an opportunity, do you want to do this to mom and dad, or do you want to wait, then you sort of have your direction from that person who's the patient.
Mark, what might trigger someone to have a DNR?
Often going to the hospital triggers it. A lot of times, I'm positive that almost 100% of the time, the hospital will ask you whether or not there's a medical power of attorney and ask you whether or not you want to sign a DNR. And as you told me earlier, the DNR has to be signed by a doctor as well. Although I'm just telling you because Monica said that, I'm actually a CPA and not an MD or DO.
State laws vary.
Yep.
Sometimes you need witness signature, sometimes you need a notary. State laws vary.
Right. Which is another reason why you need it, not necessarily with the DNR, because the hospital will help you take care of that, but with trusts and powers of attorneys, the fact that your state may require some of that stuff needs to be taken care of.
Mm-hmm. In advance.
Because you go print something off the internet and don't follow your state law, it may just be totally invalid. It probably will be, especially if it's challenged by a third party, like another child or something.
Mark, thank you for providing an introduction to a couple of topics that are oftentimes difficult for people to discuss, yet as we discussed here during the episode, it's important to be informed and intentional as you make your decisions. So I want to thank everyone for joining us during today's episode, and encourage everyone to go to onthemark.cpa to provide any questions or to sign up to become a guest host for a future episode. Before we sign off today, we have some bonus content that Mark is going to share with us, some updates on the tariffs.
Yes, so last week we had an episode about tariffs, and I just wanted to give a little bit of perspective on this. So this week, a new commissioner of the IRS was sworn in. He has a history of not being a fan of the IRS, and he's actually promoted the abolishment of the Internal Revenue Service. So this dovetails into tariffs. Why? Because there is ongoing evidence that the current administration would like to replace the income tax with tariffs. And that's some of the fuel for why we have tariffs. So I'm telling my audience this because I want them to keep continuing to listen and read about these topics so they can stay informed. Just because I'm saying they're leaning toward it doesn't mean that there's been a bill passed and we're going to abolish it. But it has been a Republican covenant to talk about a national sales tax. And this is a sales tax. A tariff really is a sales tax, right? Because you're paying an add-on on top of the original price. So this is a sales tax. So if there was some kind of move to either abolish or lower income taxes through the Internal Revenue Service, then there would be need a corresponding revenue raiser, which would be tariffs. Now, how would that affect the economy? Don't know. I mean, we mentioned in our episode that a sales tax is what we call a regressive tax, meaning that it has a higher financial impact on lower income people than wealthy people, just for the ability of disposable income. But these are something that I believe my audience needs to continue to question and also to follow. And we're going to, we talked about the big beautiful bill a couple weeks ago. We talked about tariffs. There's going to be updates on all these things, and we're going to try and bring them to you as they come, while still covering our topic of the week, so to speak. And we always welcome questions, because we're sitting here having these podcasts and having these discussions thinking we know what the questions are without somebody asking the questions, and we may be missing questions that you have. So again, welcome those. It's made the questions that we have gotten so far has made this episode each episode much better than it was, because we're answering a question from a real person instead of from our minds, or what we discuss is what our content is going to be. So I thank everybody again for listening.
All content provided on this podcast is for informational purposes only. No representations are made as to the accuracy or completeness of information that is presented. On the Mark, its owners, collaborators, and guests will not be liable for any errors or omissions, nor for any losses, injuries, or damages from the use of this information.